oral arguments on pre-hearing motions filed in the matter of Nicholas Gee, docket number 24-275-T. Representing Mr. Gee is Ms. Jill Pratt.
That's correct. Thank you, sir.
And representing Office of State Police is Ms. Juliet Encino. Counsel.
This is a fairly straightforward matter for your consideration because the rules are abundantly plain. First of all, Officer Gee has served the state police for a number of years. He was and is a disabled, honorably discharged veteran of the United States Army, having served in Afghanistan. In May 27th of 2022, he received a notice indicating that he was being placed on paid administrative leave as a result of some alleged criminal investigation by the Office of Veterans Affairs, which, so you know, resulted in absolutely nothing as it relates to Officer Gee. At that time, he was required under Rule 12.4 of the State Police Commission Rules to be advised of the intended action, the reasons therefore, and an opportunity to respond, none of which occurred. Instead, he was simply placed on administrative leave. And in fact, when you look at the letter, which is in the actual appeal, which I offer file and introduce into the record of this proceeding, there is no notice of the intended action to be taken by state police. And aside from a reference to a criminal investigation such as it was, there is no notice of the intended rules or the potential rules that Officer Gee was accused of potentially violating. That is fatal and was fatal on May 27, 2022. We fast forward. Under the Louisiana State Police Commission rules, you have 60 days to conclude the investigation of any state trooper. Although you guys have opted out of the Police Officer Bill of Rights, you do have a similar requirement. And your requirement is again found in 12.4. The 60 days from even generously saying May 27, 2022 would have expired, unless my math is really bad, by July 25th, 2022, or 26th, give or take a day. Nothing happened. Officer Gee was not issued any kind of notice of intended disciplinary action at that time. Instead, the next notification received by him was on August 10th, 2022, also a letter which you have in the record. At that time, he received a letter saying that, quote, if I determine you should not be returned to duty, I intend to place you on enforced leave, and specifically said Louisiana State Police is, quote, continuing its investigation at that time, greater than 60 days after the initial notification, as required under 12.4. What didn't happen at that point in time was no further communications with Officer Gee, I believe, until 2024. In the interim, Officer Gee had to come back here and ask this commission to require state police to return him to duty, which happened. However, in that interim period of time, Officer Gee exhausted every single piece of leave that he had and was on unpaid leave status the entire time for about a 2-year period of time. I know state police argued in their brief, well, he wasn't prejudiced because he got paid. Well, he got paid his time that he earned. And when that was exhausted, nada. And here's the problem with that. The problem with that is that under your rules, 12.19 little number I, if the appointing authority or his designee requires an extension of time within which to complete the investigation, or if an extension of time is jointly requested, and the trooper has been placed on leave pending investigation under Rule 12.4, which is what they claim they did, the trooper shall be continued on paid administrative leave pending investigation until the completion of the investigation if the appointing authority finds that continued leave is warranted under 12.4, none of which ever happened. And so the problem that we have is state police now comes in 2024 and decides, as a result of some sort of media article, that they need to now do something more about Officer Gee. So what do? They call him in sometime in July of 2024. They make him sign a document on July 16th that says, we were actually suspending our investigation all these last 2 years, and so you need to agree that we had suspended it and give us even more time. Officer Gee, who by then, by order of this commission, had been returned to his job, hastily signed it as he had no other alternative. But the problem is your rules do not allow somebody to come back and retroactively suspend some sort of investigatory period. You just don't. By then, it had long expired under your own rules. And I'll also point out that if state police wanted some sort of suspension pending some sort of investigation, well, that is provided for in Louisiana State Police Commission Rule 12.5, which specifically provides for the suspension or administrative leave pending criminal proceedings. However, it reads as follows. Upon the arrest or indictment of or the issuance of a criminal summons to an employee at the request of the appointing authority, the Commission may allow the suspension of the employee during the pendency of the criminal proceedings. This suspension may be for such duration and under such conditions as the Commission may allow. The problem is Officer G was never arrested, indicted, or issued a criminal summons. But even fundamentally, to the extent state police wants to co-opt little pieces of Louisiana State Police Commission Rule 12.5 and say, hey, we can have a suspension during criminal investigation, they never came to you and asked permission. Instead, by July of 2022, the 60 days were over. Instead, he received a notice on August 10th, 2022 that says, hey, we're still investigating you, and if I determine you should stay off of work, then I'm going to require you to take enforced leave. That if was never followed up by any other correspondence from state police. Nothing. Zero. And so what happened is, at some point in time thereafter, August 10th, after the expiration of the 60 days, Officer G was then forced to burn all of his leave, every single dime, penny, and nickel of it. And only until this commission ordered him back to work February 15th did he actually return to work. And so I will also note, as I pointed out in my filings with this commission, even though he was ordered back February 15th, he wasn't even returned until February 23rd. I submit to you this matter is ripe for summary disposition. It is ripe because there have been clear violations of your rules. The rules exist to protect the civil service status of state police troopers like Officer G, disabled veterans who have served this country and the people of this state. I ask that this madness, and I hate to use that word madness, be over. It has been 3 years of this man's life, and every dime he earned in accrued leave is gone. He was disenfranchised as a state police trooper, and all he wants to do is to be returned to duty. Thank you.
Good morning. LSP respectfully requests that this commission deny Mr. G's motion for summary disposition. When LSP received notice on May 26, 2022, that Mr. G was the subject of a federal criminal investigation, Captain Eric Cuenca verbally advised him that he was being placed on administrative leave pending investigation, which also occurred on May 26, 2022 at 5 p.m. LSP acted in accordance with the Commission's Rule 12.4a, which states, where in the judgment of the appointing authority, excuse me, there is reason to suspect that an employee has engaged in conduct which would warrant disciplinary action, but the appointing authority does not then possess sufficient facts to support a disciplinary action, and the employee's continued presence on the job or performance of his duties reasonably pose a significant hazard or danger to the general health or safety or the efficiency of the public service. The employee may, either verbally or in writing, be placed on administrative leave with pay. Again, on May 26, 2022 at 5 p.m., Mr. G was verbally notified by Captain Cuenca that he was being placed on administrative leave pending investigation. Additionally, a letter dated May 31st, 2022 and served on Mr. G on June 1st, 2022 at 8:50 a.m. in the morning, which is Exhibit 1 attached to my opposition to this motion, and I would like to offer, file, and introduce into evidence. Mr. G was notified in writing that he would be placed on administrative leave pending investigation. The letter not only confirmed Mr. G's verbal notification from Captain Cuenca, the letter advises Mr. G that he's being placed on administrative investigation pending, administrative leave pending investigation because of allegations that he received federal funding of by fraudulent means. This letter continues to meet the requirements of the Commission's Rules 12.4a in that it notifies Mr. G that his conduct, if confirmed, could warrant disciplinary action, but at the moment, LSP did not possess sufficient facts to warrant a disciplinary action. Finally, this letter notifies Mr. G that his continued presence on the job or performance of his duties reasonably possess a significant hazard or danger to the general health or safety or the efficiency of public service. Mr. G was notified that this administrative leave pending investigation was with pay, and this leave shall not exceed the 400-hour quota. Now, with the limited information LSP had, a letter dated May 27, 2022 notified Mr. G that he was the suspect of an administrative investigation. Mr. G was served with this letter and signed. He received this letter also on May 27, 2022. This is Exhibit 2 attached to my opposition, which I would like to file, offer, and introduce into evidence at this time. This administrative investigation letter served to Mr. G met the requirements of 1218B, which states when no formal complaint is made against a trooper, but the incident justifies an investigation, the appointing authority has or his designee shall cause an investigation to be initiated within 14 calendar days of the date that Internal Affairs, the troop or section commander, or anyone above the commander's chain of command learns of the incident. Captain Planko learned Mr. G was the subject of a federal criminal investigation on May 26, 2022. LSP timely and in accordance with Rule 1218B notified Mr. G he was the subject of an administrative investigation. LSP followed the Commission's rules. The administrative investigation letter notified Mr. G that he was the subject of an administrative investigation because LSP was notified of his involvement in an ongoing federal criminal investigation being conducted by the Department of Veterans Affairs, the Office of Inspector General, and the FBI. The letter goes on to state that the criminal investigation contains information that alleged he violated laws by committing theft of government property, wire fraud, and also made false statements violating Title 18 of the U.S. Code, Sections 641, 1343, and 1001. The letter also notified Mr. G that LSP knew he participated in an interview pertaining to this federal criminal investigation on May 23, 2022, but he failed to notify any of his chain of command that he participated in this interview. Now, Mr. G is was under federal criminal investigation, and LSP did not have any intimate knowledge or control over this federal criminal investigation. On July 1st, 2022, LSP invoked Rule 1219G and H and suspended Mr. G's administrative investigation. Rule 1219G states nothing in this paragraph shall limit an investigation of alleged criminal activity. Rule 1219H states the investigation of criminal activity may suspend the 60-day period for completing the administrative investigation. LSP followed the Commission's rules. Mr. G wants this Commission to believe that LSP has cherry-picked the rules we want to apply. What LSP does is actually go straight to the rules that apply to this unique administrative investigation. LSP invoked 1219G and H because these two rules specifically apply to the extension of time of an administrative investigation when there's also an ongoing criminal investigation. Mr. G did not receive notice of the administrative investigation being suspended because there's no notice requirement in the rules. Internal Affairs did their due diligence and documented in their records management system that the administrative investigation was suspended. The commission rules also allow for an administrative investigation to be suspended due to a criminal investigation, but does not require a notice to be given to Mr. G when an administrative investigation is suspended. Again, LSP followed the rules. Mr. G was notified when required by commission rules when adverse employment actions were taken. He was given his due process when it came to his employment and every benefit of the doubt. In a letter dated August 10th, 2022, which he signed, he received the letter on August 11th, 2022. He was again given notice because an adverse employment action was being taken. This is Exhibit 3 attached to my motion, which I would like to file and offer and introduce into evidence at this time. Mr. G was given notice that his allotted 400-hour quota of administrative leave pending investigation was going to run out on August 11, 2022. The letter states that he is still the subject of an ongoing federal criminal investigation and receipt of federal funds. And I would like to remind the commission, still at this time, LSP does not have intimate knowledge or control of this federal criminal investigation. The letter advises Mr. G that due to this ongoing federal criminal investigation, he is being placed on enforced compensatory leave, which at that time he had 522 hours. This letter goes on to advise Mr. G that if he exhausted his compensatory time, and Colonel Davis felt that he should not be returned to work, he would be placed on enforced annual leave, which at the time he had 2,060 hours. The placing of Mr. G on enforced compensatory leave was in accordance with Rule 1129D, which states, an employee who has been credited with compensatory leave may be required by his appointing authority to take all or part leave at that time. Mr. G was placed on enforced compensatory leave from August 15, 2022 to November 17, 2022. On November 17, 2022, Mr. G was placed on enforced annual leave in accordance with Rule 11.9A. which states an appointing authority may require an employee to take annual leave whenever in his administrative judgment such actions would be in the best interest of the department. Mr. G received the notice as required by commission rules. Mr. G was not prejudiced at any time. He not only received his pay during this time, but he and his family were allowed to keep their benefits and receive benefits. Mr. G was allowed to keep his job while he defended himself in this ongoing federal criminal investigation. At no time during the suspension of the administrative investigation was Mr. G prejudiced. He was never contacted by anyone with internal affairs. Again, LSP followed the rules. When LSP received notice on July 2nd, 2024, that the U.S. Attorney's Office was not pursuing charges related to this ongoing criminal federal investigation of Mr. G, LSP reinitiated the administrative investigation. Mr. G received written notice in compliance with Rule 1218. Every time Mr. G faced an adverse employment action, he was given notice. LSP complied with the commission's rules. The suspension of the administrative investigation is not the type of employment action that requires notice. Mr. G's motion should be denied by this commission because LSP followed the rules. When it comes to Rule 12.5, at no time does LSP invoke this rule or mention this rule in the opposition. And LSP never applied this rule to Mr. G because he was never suspended. Mr. G was placed on enforced compensatory leave and enforced annual leave. And this allowed him to keep his and his family's benefits while he defended himself in his criminal investigation. both of which were within Colonel Davis's authority and under the commission rules. Thank you.
If I may. First of all, so we are abundantly clear, my client was never arrested, cited, or issued a summons or anything. Secondarily, the notion that he, quote, received notice all along is it's inaccurate. If there was a notice in November of 2022 to my client about you're now on forced compensatory leave, it doesn't exist. It hasn't been filed by the state police in this matter, and my client did not receive it. I would point your attention to one thing he did receive, which is the August 10th, 2022 letter. And what it says precisely is, on May 26, 2022, at approximately 1700 hours, you were placed on administrative leave pending investigation pursuant to LSPC Rule 12.4. Administrative leave pending investigation cannot exceed 400 working hours. It is estimated that you will have exhausted the 400 hours of administrative leave pending investigation on or about August 11th, 2022. It goes on to say, not that we are now placing you on enforced leave, but it simply has an if. And the if is, if somebody down the road determines that they want him to stay on leave pending the investigation, which on August 10th, according to state police, was still ongoing by them. There is nothing in the August 10th, 2022 letter that says we are suspending our investigation. In fact, it says to the contrary. We are continuing our investigation. And then it goes on to say, if we get to the 400 hours and we haven't concluded our investigation, then we are putting you on enforced leave. A notice he never received. In fact, what happened was, she's correct, sometime later in August, all of a sudden they started burning his time. There was no written notification of a determination that he must be then placed on enforced leave. In fact, what's on August 10th is, if we think we might have to, then we will. That's not sufficient. It is not comporting with the requirements of written notice and an opportunity to respond. Furthermore, one thing that I will point out to you that was not read by counsel when she read the rules is this part in 12.4. She left off the last sentence under subpart A, and this is what it says. This is be placed on administrative leave with pay. Then it says, such leave shall not reduce the employee's annual or compensatory leave. That's the part she did not read to you from 12.4A. And that's true. Because you can't say to this guy at some point in time, we're placing you on paid administrative leave pending our investigation, which they did initially on May 27th. Then turns around and on August 10th say, we are still conducting our investigation, and if we haven't finished it in 400 hours, then we're going to place you on enforced leave, but never gave him notice that that occurred. And more importantly, by the time we even got to August 10th, the 60 days were gone. And at no time did my client receive any notification of this quote-unquote alleged suspension, which they're saying was some sort of computer entry. 3 years later, almost 3 years later, they're coming into this commission saying, well, we had a computer entry. We never told Officer G about that. We burned all of his time. We realized he's never been criminally prosecuted. He was never indicted, never arrested, and never issued a summons. But now we are firing him years later. For the reasons we submitted and those which are contained in your rules. Entirely, not omitting the last sentence of 12.4A, but all of your rules. Summary disposition is warranted. This is a man who is a disabled, honorably discharged veteran who served the people of the state of Louisiana. He should be returned to work. Thank you.
I have a question relative to the letter dated July 15th, where the administrative investigation was resumed. If the rules don't require you to notify the employee when the investigation is suspended, do the rules require the notification that the investigation has been resumed?
LSP followed Rule 1218A that asserted that they were reinitiating the investigation. So they put him on notice that now your administrative investigation was being.
So why was there no, if the notice isn't required in the rules, then why did the state police feel it necessary to inform him that the investigation was no longer suspended?
Because at that point, they would be starting the process of investigating him, where they would be reaching out to him and making contact, so he was put on notice that, hey, we're gonna be the investigation is now on, it has now reinitiated.
So who determines, and how is that documented, how is the suspension of the administrative investigation documented, or is it just a note made in a file somewhere?
So at that time, internal affairs investigators made a documentation in their records management system on July 1st that the administrative investigation was being suspended. The rules doesn't require notice to notify him of his suspension of his administrative investigation, but they documented it. They went above what's required of them, and it made a note in the computer, and it's documented that his administrative investigation was suspended.
Got a question on that as well. Maybe it matters, maybe it doesn't. The way I read 12.19H, it says the investigation of criminal activity may suspend the 60-day period for completing the administrative investigation. So, as I read this, the investigation remains open.
I'm sorry, what rule?
12.19H. The investigation remains open at all times. The only thing that's suspended, as I read the rule, is the 60-day time period. In other words, he's under administrative investigation this entire time. It's just the 60-day period is suspended. Is
Yes.
that correct?
Yes, sir.
And you're right there. I saw nothing that required notice to Mr. G that it was being suspended at the time period, but I also saw nothing in the LSP's communications that was contradictory to the fact that LSP considered the time limit suspended pending that criminal investigation. Is that right?
Yes, sir.
Okay. And then Mr. G did execute, no one's mentioned, a voluntary extension of time to complete the administrative investigation. He acknowledged these facts, it seems.
Yes, on July, I have that date.
July 1st.
I'm sorry, on July 16th, 2024, LSP obtained written consent from Mr. G to extend the administrative investigation.
And that's allowed under the rules, correct?
Yes, sir.
And also, I think he noted, there are several statements that he noted that it says the administrative investigation was suspended. Again, I'm splitting hairs, but correctly stated, I think it's the time period to complete it was suspended on July 1 and reopened on July 15, 2024. July 1, 2022 was the suspension. July 15, 2024 was the when it was reopened. He didn't challenge that it had been suspended and that it was being reopened.
Yes, sir.
And it looked like he said he gave it freely and voluntarily, and he had not been given anything in exchange, and he had not been coerced, and he was doing this by his own free will. And that's allowed under 12.9D, specifically allows the troop and the employee to enter into this kind of agreement, does it not?
Yes, sir.
And when I looked at it August 10th, I didn't see, Ms. Kraft said that it said the state police was continued its investigation, but I think it correctly reads that it notifies Mr. G that he is still the subject of an ongoing criminal investigation. That's what it actually says, isn't it?
Yes.
And then I noticed in the appeal pack, there was a letter from Mr. G's lawyer dated July, I think it was July 15th, or July 10th of 2024, an email from Harry Daniels to Mr. G advising him that Allison, who is the U.S. prosecutor, indicated that the state police headquarters is aware that the federal government will not be prosecuting you or anyone else. And that, to me, seemed to line up with the date that state police says, which was only a few days before July 2nd of 24, that it learned
Yes.
that there would be no further
Yes.
in action taken with respect to that investigation.
Yes, and I mean, The reasons are unknown why they chose not to prosecute, but they made the choice not to prosecute him.
And then, the enforced annual leave or the compensatory leave, I think, and let me see if I understand your position, is that the appointing authority, are you saying the appointing authority has the discretion to determine whether it wishes to require Mr. G to take compensatory leave under 11.29D or enforced annual leave under 11.9?
So the 11.29 allows the appointing authority, which at this time was Colonel Davis, to, instead of Mr. G not receiving any type of compensation, to start using his to enforce compensatory leave, which they did, and they exhausted the 522 hours. And once the 522 hours were exhausted, Colonel Davis placed him on enforced annual leave, which is under 11.9 of the rules.
And Ms. Crawford, that's to you, are you contending that was not permissible, that they could not require him to take compensatory leave and then enforced annual leave? And
Yes,
so,
sir.
what do you rely on for that?
And in the plain language of the August 10th letter, you cannot issue a letter to a state trooper and say the following language. As of the date of this letter, your current straight compensatory leave balance is 522 hours. You will remain on forced compensatory leave until further notice. No further notice was given. In the event your straight compensatory leave is exhausted and I determine you should not be returned to duty, I intend to place you on enforced annual leave in accordance with LSPC Rule 11.9. Nothing else happened after that, and he was required to receive notice at that point in time. But you cannot do some sort of, if later on in the future I might think that the star is green, and then all of a sudden you just do it. It requires notice under the rules, your rules.
And what rule are you pointing to that says he requires?
Specifically 11.9. You can't give a conditional thing, I intend, I might, if I make this determination in the future. He has to receive notice the determination has been made. Furthermore, Mr. Du Bois, I will point you to the fact that the August...
Point to the language in 11.9 that you're resting on, that formal notice.
Because he's got to receive notice that he is...
You said you mentioned 11.9. Show me where you got it.
That's where it says in 11.9.
What would that be?
I don't have it sitting in front of me, sir. My apologies.
Okay.
But I also wish to point out in your questioning of counsel as it relates to the August 10th letter, it is very clear that he is remaining on administrative leave pending investigation. If their position is there was no investigation, then why does their communication say pending investigation? Because the investigation continued.
The criminal investigation or the administrative investigation?
The administrative investigation, that's exactly what their letter says. On May 26th at approximately 1700 hours, you were placed on administrative leave pending investigation pursuant to Louisiana State Police Commission Rule 12.4.
Right.
Administrative leave pending investigation cannot exceed 400 working hours. This is what they wrote. It is estimated you will have exhausted 400 hours of administrative leave pending investigation, their investigation under 12.4, on or about August 11th, 2022. The problem is they never, ever, even in this letter, said anything about we are suspending this, that the administrative investigation is being suspended, and in fact the communications only to my client were that he's being continued on administrative leave pending their investigation.
The administrative investigation.
Their administrative investigation, yes sir, and that's what it says.
And you acknowledge, though, that the rule allows the 60-day period within which that investigation must be completed to be suspended when there is an ongoing criminal investigation.
No sir, I don't.
You don't. Okay.
And that's where we look at 12.191, or a little odd.
All right, let's read that. I'd like
Yes.
to see your interpretation.
It says, if the appointing authority or his designee requires an extension of time within which to complete the investigation, or if an extension of time is jointly requested, and the trooper has been placed on leave pending investigation under Rule 12.4, August 10, 2022, that trooper shall be continued on paid administrative leave pending investigation until the completion of the investigation if the appointing authority finds that continued leave is warranted under Rule 12.4.
And that would limit it to 400 hours, right?
No, sir.
12.4
They-
has been expressed.
It says paid administrative leave. That is not putting them on enforced leave.
But-
Paid administrative leave, which they did not continue this man
So
on.
you're saying they're not allowed to put him on enforced leave?
they were required, if they're doing this investigation, which they are, and if they want time to suspend the investigation, which they're now claiming they do, 12.19I required they keep my client on paid administrative leave and not touch his leave, period, which they did not do. That's what the rule says.
But H above it says that the investigation, the administrative investigation timeframe can be suspended if there's a pending criminal
Well,
investigation.
let's say that's true.
It is.
Then how do you deal with 12.19I? Because if that were the case, my client would have stayed on paid administrative leave the entire time.
For more than
Otherwise,
400
12.19, excuse me?
For more than 400 hours?
Yes, sir, that's what
Okay.
12.19I says.
Okay, but it also says if it's warranted under 12.4, and 12.4 limits it to 400 hours.
But 12.4 is also where we started from. Yes, sir, and he should have been on paid administrative leave
But it's
the
got to
entire
be
time.
warranted under 12.4, and part of 12.4 is an express limitation to 400 hours. So you're saying they can abrogate 12.4
No, sir.
under 12.1?
No, sir, what it says here is if
It's
continuing
agreed, yeah.
leave is warranted under 12.4, which means he should have been on paid administrative leave this entire time.
Up to 400 hours.
No, sir, if they wanted to extend it, then they could have under 12.191 if they made that finding, which they did not do.
So you're saying that he could not, if he was on administrative leave,
And more importantly, that 400 hours were over.
you're saying while under the administrative investigation, he had to be only under administrative leave pending investigation?
That's what your rules say. That's 100% what your rules say.
Look at 11.30. It says an employee in the classified service is required by the appointing authority to use annual or compensatory leave while under administrative investigation. The following shall apply. So this seems to suggest to me that when someone is on administrative leave, the appointing authority can require them to use annual or compensatory leave.
Except when they're trying to suspend an investigation, which is what 12.19I says. And that's what they're now coming in claiming without evidence. They haven't presented to you anything from a computer, no affidavit, and no testimony. We have a guy who was forced out on leave for an excessive period of time, who not only had to burn all of his time, but then went in unpaid leave status and had to come to this commission to order state police to put him back to work at that time in February of 2024. Their rules require that there be notice.
Yeah,
They can't simply come back
I don't see it.
years later and say, gee, we have some computer injury.
Well, you mentioned 11.9, and I'd love to find it. I've got the rule here. I'll have to give you a copy. I don't see anything in 11.9 that requires a notice that you claim that rule requires.
It does if we're talking about leave pending an investigation, it certainly does, because you can't ignore the parameters of 12.4, which require notice. You can't. State police superintendents can't just come in and slap somebody on some leave and then change their mind. More importantly, they can't have somebody, as of at least August 10th, when the 60 days have already expired, and tell him he's still on being investigation, he's on administrative leave pending their investigation, and then claim as of August 10th, gee, we were mistaken, but 40 days earlier, July 1st, we have some sort of computer entry that we're just suspending this. And we're not actually investigating you as they said they were on August 10th. More importantly, their initial notice, all of them, look at them, May 27th, May 31st, look at them. Do they cite any potential rule that my client is alleged to have violated? Any rule? And the answer is no. And that is an absolute requirement. You can't just say we think somebody's looking into you for this particular situation. There may be a violation of rules, but we're not going to tell you which ones. Because that undercuts notice and opportunity to be heard.
But doesn't that come up later when in the
Not according to your rules.
well, I think at the outset, the way I read the intended action is being placed on leave. That's the intended action they give them notice of. I think after the investigation is complete, the appointing authority wishes to take disciplinary action, that's where they cite the rules and the reason, the Loudermeyer hearing, and the client gets the notice to be heard at that point, before discipline is imposed.
But you can't come in and take a trooper out of their job and not give them
But you can't
notice.
cite the rules and what you intend to do before you complete an investigation either, can you?
You can, in this
Well,
case.
then you'd be arguing that they made up their mind before they investigate.
No, sir, he has to get notice of the potential rule violation before he has been subjected to removal.
It
And
says
that
the
didn't
intended
happen.
action. The way I read that is the intended action would be, we intend to place you on administrative leave. That's the intended action at that stage. Because they're commencing an investigation, and I would suggest they probably don't know the rules that may be implicated, nor the conduct that's the purpose of the investigation.
Well, the problem is this is a civil service employee, and it's not a rank and file employee at will.
But
And
those other
and
rules
we
come
are
in
required
later.
to follow the rules.
Right, and the rules that I think you're saying come in later when the investigation is complete and they intend to take disciplinary action, that's when they're required to give him the notice of the action to be taken, the rules that they contend to be violated, the conduct which they contend violated the rules, and then the opportunity to be heard before they impose the action.
So the deprivation occurred when he was removed from his job as a matter of constitutional law. That's when the deprivation occurred, and that's why Loudermill, if we want to talk about Loudermill, requires notice and opportunity to be heard prior to deprivation. And in this case, they can't have it both
Well,
ways.
the deprivation being the loss of your job, not being placed on admin leave, right?
The loss,
Right.
no, the deprivation is being removed from his job. And there's a legion of cases that speak to that. Just because he got paid for a period of time and then forced to burn the time and leave that he earned, which in and of itself is a tangible employment action, does not mean he's not, nonetheless not entitled to Loudermill notice. Furthermore, then why are they telling him, May 27th, you are the subject of an administrative investigation we've begun, right?
Right.
They say it again on May 31st, and they say the investigation is continuing as of August 10th.
And at all times, don't they note that it's predicated on a criminal investigation being conducted by federal authorities?
So, the problem is, the reason that they're coming in here now trying to say there's some sort of computer injury, because they know they didn't follow the rules. And they told my client expressly on August 10th that he is the subject of their pending investigation. State police was not investigating my client, which were the two cases they cited in their brief, and they're different. Both of which arise under the Peace Officer Bill of Rights and involved investigations by the NOPD of their own officers. This is not that case.
Does that matter whether the criminal investigation is being conducted by the agency itself or an outside agency?
Well, to the extent they cited cases, it does.
Well, I think the cases stand for the proposition of just a criminal investigation, period. I don't think the agency being the same as the employer is what's relevant, but
But the problem is the criminal cases arise under the Peace Officer Bill of Rights, which this commission says does not apply to my client.
And looking at, from the time frame within which this administrative investigation started until, I think it's July 15th, is there any action that you can point to say the state police was actively pursuing its administrative investigation and conducting interviews or gathering evidence or anything like that that would be inconsistent with its position at its state?
Their August 10th letter, which says they are clearly continuing the investigation.
That-
How is that not their
Says
words?
the investigation continues, but doesn't 12.198 say the same thing? It says that it suspends the time period for completing the administrative investigation. It doesn't dismiss the investigation, it suspends the 60-day period. The investigation continues until the criminal investigation is complete, which they contend they learned of on July 6th.
That's not what they said, sir. What they said, we started it in May,
That's right.
then they say we have some sort of computer entry, nobody's testified to that, nothing. We have some sort of computer entry that says on July 1, we're suspending this investigation that has not been offered to you.
Who's the burden of proof today? Who has the burden?
They have the burden to substantiate what they're saying here. Otherwise, I can walk in and say the star is green today and you have to accept it. But they're coming in arguing against what is facially, demonstrably a violation of your rules. And all they have is, we found some sort of computer entry on July 1st, 2022, after they had allegedly been investigating for well over a month and a half. And more importantly, the thing that they told my client August 10th and which they relied on is the fact that they're still continuing the investigation. There is nothing in the August 10th letter that says we are suspending it, we are taking additional time, we've decided because the criminal investigation, whatever it was or is not concluded. And also I'll point out, during this period of time, my client cooperated fully. The fact they know.
The 10th letter would have been outside what you contend would have been the 60-day period, right?
I think that's argument number one.
Okay, so
There's
that's,
several arguments that we've made.
so that position to me would seem to be consistent that the state police deems the investigation, the administrative investigation is still open, but the 60-day period has been suspended.
I didn't write their letters, Your
Would
Honor.
you agree that would be consistent? with
No,
that?
sir, I don't. Because of what I understand is inconsistent is their own language in their August 10th letter, which says you are remaining on, and we're now gonna, if I decide later on down the road, I might send you on enforced leave.
But if they're writing a letter after the 60 days saying our investigation continues.
Oh, I don't think they thought the 60 days was over. In their letter, they think the 60 days is over August 11th. My math shows it's over on July 25th. I think they got their math wrong.
I think the August 11th reference, if I looked at the letter, but that was the 400 hours, if I'm not mistaken.
Okay,
That's not the 60 days.
okay.
All right, thank you.
Which is the 12.4 issue in the first instance. But the problem fundamentally is we can't cherry pick these words.
So what happens if someone's on administrative leave or pending an investigation that exceeds their 400 hours, then what?
Then the investigation is null and void. They have a requirement to complete that within a period of time, and they didn't.
Let's assume the period got extended either by joint agreement or by commission. If it exceeds their 400 hours,
That's a different animal if it gets exceeded before it expires, and that's the problem. They came into this guy after you had to order him back to work because they violated the rules the first time. And then they come back to him, he's back on the job, and they're like, you need to sign here. 16 days after they're claiming, oh, we arbitrarily decided July 1st, 2024 to start over again. 16 days burned from them, a month and a half burned from the first time. And now, if the position is, now they're claiming in July of 2024 that we are now starting the investigative process, well, that violates their rules. The 14-day period, by their own acknowledgement, began at least as of May 27, 2022.
that's the 14 days to initiate it.
Right, and what they're trying to get you to accept is, well, our 14-day period to initiate the investigation started again in 2024. That's what their other letter
I don't
says.
understand their position that way, but
That's what their letter says.
I understood their position to say, we learned that the criminal investigation was completed around, I think, July 2nd of 24. And do you have any evidence to indicate that that's incorrect?
Yeah, because my client was never indicted, issued a summons, or arrested.
That's a different answer. My question is.
No, so that is the facts.
No, I'm talking about a date, not a fact. I'm talking about, they say on July 2nd.
He was never subject to
Yeah,
any
never.
criminal process.
Well, he was under criminal investigation, not process.
Says
Well, your client said through an interview with the FBI on May 23rd of 2022.
of 2022, absolutely. He sure did. He went in, he volunteered, he sat down and
They read
talked.
him his rights. And they-
I don't believe that they did. I think he just sat down and gave an interview.
No, I can read it. They read him his rights.
Okay.
They-
And if I go in and talk to a law enforcement officer, they're gonna read me my rights too, or they're gonna have a
My
problem.
point is, he knew he was the subject of an investigation. They were very candid and forthcoming with him, but my
As
point
was
is,
he.
I'm going back to my original question. The state police contends on July 2nd of 24, they learned that the criminal investigation had concluded and would not result in any charges. Do you contend that date is wrong, that date?
Where is that evidence?
Do you contend that date? I'm
Yes,
sorry.
I do.
Okay, and what do you rely upon to contend that
The
date?
fact that my client gave a voluntary interview in May of 2022 and was never subject to any criminal charges.
Okay, and I get that, but I'm more concerned the date. They contend that they learned that the criminal investigation was being wrapped up with no charges to be promulgated in July of 2024, I think it was July 2nd of 24. And I'm asking, do you contend that date is incorrect?
Yes, because he was never prosecuted 2 years later after he gave a voluntary interview.
When did Mr. G learn that the criminal investigation was completed with no prosecution?
I think he was under the impression all along, although he did receive communication from his attorney sometime, I believe, in June or July of 2024.
July 10th, I believe.
Okay?
Thank you.
Sir, I also want to make clear that your rules exist for a very important reason, and that is to protect the people who serve this state.
Yes, I understand.
And on August 10th, if that's not the case, and if the 14-day period didn't start, then how do you explain their May 2022 letter? How do you explain their August 10th, 2022 letter? What happened was, there was a press story about it, and they freaked out and decided they had to do something at that point in time. But to sit here and to say, we don't have any evidence of an alleged suspension, and they're telling you there's some sort of computer entry, it's not sufficient on the face of the documentation. And I would urge you to protect the troopers of this state and not allow arbitrary action years later to take place.
I'm going to let you address one document that I brought up, the voluntary extension of time to complete the administrative investigation that was signed by Mr. G on
Yep.
July 6th. You want to address that at all?
Yes,
I
sir.
didn't bring it up, so I'll give you a chance.
Yes, sir. And as I pointed out in our brief and in our thing, he was under duress at the time, complete duress. Because this thing, as far as he knew, was over. He had been back to work since February of 2024. Now, let me ask you something. If this situation was the investigation, the criminal matter, the superintendent of state police thinks he's a threat and a harm to everybody else, then how come you had to order him back to work in February of 2024? Let me ask that question.
Well, let me pose another question back. You say he's under duress, I mean, is Mr. G, you're gonna testify to what?
Mr. G can't be here today because he has nothing in terms of income. He's trying to scrap and save as much as he
But
can
then how
at a
do
job.
we conclude that there was some duress? How do we not take the document at face value without something, evidence to the
Well,
contrary?
apparently you're taking the assertion by state police that there's a July 1, 2022 computer entry at face value. It's the same thing.
Well, I think there's some corroboration with the July 10th, 2024 email from Mr. G's attorney that.
No, there's not corroboration of their allegation that all of a sudden, July 1st, 2022, we suspended it, but we didn't tell him, and we sure didn't tell him on August 10th that we were suspending the investigation. Because otherwise, why go through this charade of placing him on if I determine later, and that's what the letter says, and that's improper. If I determine later I want to put you on enforced leave, then you'll be on enforced leave. No further notice after that point in time.
Isn't that notice at that point that if there is?
No, sir, you gotta give notice when you put him on enforced leave, not if I determine later, and that's what the letter says on August 10th.
Thanks.
This time I'll entertain a motion to enter executive.
So, second.
Roll call vote, please.
Jared Ricky,
Yes.
Mark Cole,
Yes.
Michael DeBose,
Yes.
Jim Kowalski,
Yes.
Ross Bourgeois,
Yes.
Stephen Gidry,
Yes.
and Monty Mazzarella.
Yes, the motion carries. We'll now enter into a motion to return from executive. I'll move.
Second.
So moved and seconded. Roll call vote, please.
Jared Ricky,
Yes.
Mark Cole,
Yes.
Michael DeBose,
Yes.
Jim Kowalski,
Yes.
Ross Bourgeois,
Yes.
Stephen Gidry,
Yes.
and Monty Mazzarella.
Yes. We're now back in regular session. We'll entertain-
Mr. Chairman, I move that the motion for summary disposition be denied.
So moved. Do I have a second?
Second.
Moved and seconded. Roll call vote.
Jared Ricky,
Yes.
Mark Cole,
Yes.
Michael DeBose,
Yes.
Jim Kowalski,
Yes.
Ross Bourgeois,
Yes.
Stephen Gidry,
Yes.
and Monty Mazzarella.
I'll abstain, and the motion passes.